Questions. Here is a set of frequently asked questions in the Philippine bar exams on transportation law, especially under civil law and commercial law, along with suggested answers and legal bases. Frequently asked questions, transportation law, Philippines. 1. Question: what is the difference between a common carrier and a private carrier? A common carrier is one that holds itself out to the public as engaged in the business of transporting goods or passengers for compensation, offering its services to anyone willing to pay. A private carrier, on the other hand, undertakes transport only by special agreement and does not offer its services to the public. Legal basis. Article 1732, Civil Code, Loadmasters Customs vs. Glottal Brokerage, GR number 179446, 2010. 2. Question: is a school bus operator considered a common carrier? A. Yes. Even if a carrier serves only a limited clientele or is not issued a certificate of public convenience, it is still considered a common carrier if it engages in the business of transporting passengers for compensation. Legal basis. Vasquez v. Isia, GR number 118971, September 15, 1999, Article 1732, Civil Code. 3. Question: what is the liability of a common carrier in case of death or injury to passengers? A common carrier is liable for death or injuries suffered by passengers due to its fault or negligence. There is a presumption of fault unless the carrier proves that it observed utmost diligence and that the cause was not attributable to it. Legal basis. Article 1755, 1756, Civil Code. 4. Question: when does the duty of extraordinary diligence begin and end in passenger carriage? A. The duty begins from the moment a person offers himself as a passenger in a place under the carrier's control and ends once he has safely disembarked and left the premises of the carrier. Legal basis. Article 1754, Civil Code, Bachelor Express v. Isia, GR number 85691. 5. Question: what defenses are available to a common carrier in case of loss of goods? A carrier can escape liability if it proves that the loss was due to a. natural disaster or calamity. B. act of public enemy. C. fault of the shipper or owner. D. nature of the goods, or E. order of competent public authority. Legal basis. Article 1734, Civil Code. 6. Question: is stipulation limiting liability valid in contracts of carriage? A. Stipulations limiting liability are generally valid, except when a. the loss is due to the carrier's own negligence or willful acts. B. it is contrary to public policy. C. the stipulation was not freely agreed upon. Legal basis. Articles 1744 to 1745, Civil Code. 7. Question: in maritime law, when is a carrier presumed negligent in case of collision? A. When a vessel collides with another that is properly moored or anchored, the moving vessel is presumed negligent unless proven otherwise. Jurisprudence. Philippine Rabbit Bus Lines v. Isia, GR number 106322. 8. Question: what is the legal basis for the liability of air carriers in international transport? A. International air carriers are governed by the Warsaw Convention and Montreal Convention, which limit liability for death, injury, or loss of baggage unless there is willful misconduct or gross negligence. Legal basis. Warsaw Convention, ratified by the Philippines, Civil Aeronautics Act, RA 776. Here's part 2 of the frequently asked questions in the Philippine bar exams on transportation law, with legal bases and jurisprudence where applicable. Frequently asked questions, transportation law, part 2. 9. Question: what is the doctrine of proximate cause in transportation law? A. Proximate cause refers to the direct, natural, and uninterrupted cause of the injury or damage. In transport law, if the carrier's negligence is the proximate cause of death, injury, or damage, liability attaches even if other factors contribute. Legal basis. General Tort Principles, Article 2176, Civil Code. Bachelor Express Incorporated v. CA, GR number 85691. 10. Question: Can a common carrier be held liable for the acts of strangers or third parties? A. Yes, unless it proves that it observed the diligence of a good father of a family to prevent the act or damage. Legal basis. Article 1763, Civil Code. 11. Question: What is the liability of a common carrier in case of hijacking or robbery of passengers? A. The carrier is presumed negligent unless it proves due diligence was exercised to prevent or minimize the risk. Liability attaches, especially if security measures were lacking. Legal basis. Articles 1733, 1755 to 1756, Civil Code. Dangwa Transportation VACA, GR number 95582. 12. Question: What is the last clear chance doctrine in collision cases? A. Even if both parties are negligent, the one who had the last clear opportunity to avoid the accident but failed to do so is solely liable. Jurisprudence. Phil. Rabbit Bus Lines VACA, GR number 106322. 13. Question: What is the duty of a carrier regarding the condition of its vehicles? A. A common carrier must ensure that its vehicles are safe, fit, and properly maintained for transport. Legal basis. Article 1757, Civil Code. 14. Question: Can a passenger claim damages for moral injury even without physical injury? A. Yes, moral damages may be awarded for mental anguish, humiliation, or social embarrassment resulting from breach of the carrier's duty, such as unjustified offloading. Legal basis. Article 2217, Civil Code. Philippine Airlines VACA, GR number 123238. 15. Question: Is a bus line liable for an accident caused by its driver who was drunk or speeding? A. Yes. The carrier is liable for acts of its employees done within the scope of their duties. It cannot escape liability by alleging that it exercised due diligence in hiring. Legal basis. Article 1759, Civil Code. Bachelor Express VACA, GR number 85691. 16. Question: When is a carrier not liable for delay in the delivery of goods? A. If it can prove the delay was due to a fortuitous event, act of God, or force majeure, and that it exercised due diligence to prevent the delay. Legal basis. Article 1734 to 1735, Civil Code. Here's part 3 of the frequently asked questions in Philippine bar exams, transportation law, focusing on maritime and air transport, with legal basis and case references. Frequently asked questions, transportation law, part 3, maritime and air transport. 17. Question: What is the obligation of a ship captain in case of marine casualty, e.g., collision, grounding? A. The captain must ensure the safety of passengers and crew, report the incident to maritime authorities, and, if necessary, initiate salvage or abandonment procedures. Legal basis. Code of Commerce, Articles 609 to 612. Marina Regulations. 18. Question: What is jettison and when is it justified? A. Jettison is the voluntary throwing overboard of cargo to lighten the vessel in an emergency. It is justified when necessary to save the ship, cargo, or lives. Legal basis. Code of Commerce, Article 815. TransAsia Shipping Lines VACA, GR number 123349. 19. Question: What is a bill of lading and what is its legal significance? A. A bill of lading is a written acknowledgement by the carrier of the receipt of goods for shipment, and it serves as a contract, receipt, and document of title. Legal basis. Code of Commerce, Article 651. Eastern Shipping Lines VEIAC, GR number 71301. 20. Question: What is the liability of a carrier in case of unseaworthiness of the vessel? A. The carrier is liable if the vessel was unseaworthy at the start of the voyage and the unseaworthiness caused loss or damage. The duty to provide a seaworthy vessel is non-delegable. Legal basis. Code of Commerce, Article 587. Loadmasters Customs vs. Glottal Brokerage, GR number 179446. 21. Question: Are air carriers considered common carriers? A. Yes. Air carriers are considered common carriers and are bound by the same standard of extraordinary diligence. Legal basis. Article 1732, Civil Code. Philippine Airlines v. ICA, GR number 123238. 22. Question: Can a passenger file a claim under Philippine law even if the air ticket states liability limits under international conventions? A. Yes, but if the air travel is international in nature, the liability of the carrier is governed primarily by the Warsaw or Montreal Conventions, which may limit liability unless willful misconduct is proven. Legal basis. Warsaw Convention, Montreal Convention. Lufthansa v. ICA, GR number 114508. 23. Question: When is the airline liable for delayed flights or offloading? A. The airline is liable if the delay or offloading was unjustified or due to the carrier's negligence, and the passenger suffers damages as a result. Legal basis. Article 1733, 1755, 1170, 2217, Civil Code. PAL v. ICA, GR number 123238. 24. Question: Can a carrier be held liable for overbooking or failure to accommodate a confirmed passenger? A. Yes. Such act constitutes a breach of contract of carriage. The passenger is entitled to damages even without proof of actual loss. Legal basis. PAL v. ICA, GR number 123238. Article 1170, Civil Code. Would you like a final Part 4 with mixed bar-style questions, problem format? Here is Part 5 of the frequently asked questions in Philippine bar exams, transportation law, continuing with bar-style situational questions and answers. Here is Part 4 of the frequently asked questions in Philippine bar exams, transportation law, focusing on problem-type questions and mixed scenarios commonly asked in bar exams. Frequently asked questions, transportation law, Part 4, bar-style problems. 25. Question: A passenger of a provincial bus was robbed at gunpoint inside the bus. The carrier argued that it was a fortuitous event. Is the carrier liable? A. Yes. Common carriers are liable for the acts of strangers, e.g., robbers, if it is shown that the carrier failed to exercise extraordinary diligence to prevent the crime. The presumption of negligence applies. Legal basis. Article 1733, 1755, and 1763, Civil Code. Dangwa Transportation v. ICA, GR number 95582. 26. Question: A shipping company delivered perishable cargo 2 days late, causing spoilage. It claims bad weather caused the delay. Is it liable? A. Yes, unless the carrier proves that the delay was solely due to force majeure and that it exercised due diligence before, during, and after the event to prevent the delay and damage. Legal basis. Articles 1733, 1734, 1735, Civil Code. Eastern Shipping Lines v. EIAC, GR number 71301. 27. Question: A ship sank during a storm. The owner claimed it was an act of God. Evidence showed the ship had expired safety certificates. Is the carrier still liable? A. Yes. The defense of force majeure fails if the vessel was unseaworthy at the start of the voyage, as the loss was partly due to the carrier's fault or negligence. Legal basis. Article 1734, Civil Code. Code of Commerce, Article 587. Loadmasters Customs vs. Glottal Brokerage, GR number 179446. 28. Question: A passenger missed his international flight due to airline overbooking. He suffered embarrassment and financial loss. Is he entitled to damages? A. Yes. The Airlines Act constitutes breach of contract. Moral and actual damages may be awarded, especially if gross negligence or bad faith is proven. Legal basis. Articles 1170, 2217, Civil Code. PAL v. ICA, GR number 123238. 29. Question: A courier service refused to accept liability for a lost package, citing a waiver clause in the receipt. Is the waiver valid? A. No. Stipulations limiting liability are void if the loss was due to the carrier's negligence or the stipulation was not clearly and freely agreed upon. Legal basis. Article 1744 to 1745, Civil Code. Yamato Transport VECA, GR number 136978. 30. Question: A bus struck a pedestrian while avoiding a reckless motorcycle. The pedestrian sues the bus company. Is the company liable? A. Yes. The bus company is presumed negligent unless it proves that its driver exercised extraordinary diligence and that the accident was solely due to the fault of a third party. Legal basis. Articles 1755, 1756, Civil Code. Bachelor Express VECA, GR number 85691. Frequently asked questions, Transportation Law, Part 5, more bar-style situational questions. 31. Question: A cargo was damaged in transit due to improper stacking by the shipper. The carrier was sued for damages. Is the carrier liable? A. No. If the damage was due solely to the fault of the shipper, such as improper packaging or loading, and the carrier exercised due diligence, it is not liable. Legal basis. Article 1734, 3, Civil Code. Eastern Shipping Lines VECA, GR number 97412. 32. Question: A passenger carrying a concealed weapon accidentally discharges it inside a moving train, injuring others. Is the train operator liable? A. Yes. Unless the train operator proves that it exercised all necessary precautions to screen passengers and ensure safety, it will still be presumed negligent. Legal basis. Article 1733, 1755, 1756, Civil Code. 33. Question: An airline delivered a checked-in luggage 1 week late and with missing contents. The passenger sues for damages. Is the airline liable? A. Yes. Under the Civil Code and relevant international conventions, the airline is presumed negligent for delayed and damaged baggage, unless it rebuts the presumption by proof of due diligence. Legal basis. Civil Code, Arts. 1733, 1735. Warsaw/Montreal Conventions, depending on the flight. 34. Question: A logistics company categorized itself as a freight forwarder, not a carrier, to avoid liability for lost goods. The evidence shows it arranged transport and collected payment. Is it a common carrier? A. Yes. Even if a business does not label itself a common carrier, it will be treated as such if it is engaged in the business of transporting goods for the public and for compensation. Legal basis. Article 1732, Civil Code. Loadmasters Customs vs. Glottal Brokerage, GR number 179446. 35. Question: A taxi driver diverts the route to a dark alley, causing the passenger to be robbed. Is the taxi operator liable? A. Yes. Common carriers are liable for their drivers' negligent or malicious acts committed in the course of employment. There is a breach of the duty of extraordinary diligence. Legal basis. Articles 1755, 1759, Civil Code. Latham vs. Smith, 45 Phil, 657. 36. Question: A shipping line failed to issue a bill of lading for shipped goods, and the cargo was lost. The shipper sues. Can the shipping line escape liability? A. No. Issuance of a bill of lading is not a condition for liability. If the goods were received and lost due to the carrier's fault, liability attaches. Legal basis. Article 1733 to 1735, Civil Code. Code of Commerce, Article 651. 37. Question: An international passenger flight had turbulence and an overhead bin opened, injuring a passenger. Is the airline liable? A. Yes. The airline is presumed liable for injuries to passengers unless it proves the injury was not due to its fault and it exercised extraordinary diligence. Legal basis. Article 1755, Civil Code. Warsaw/Montreal Convention provisions on carrier liability. 38. Question A. Passenger was offloaded from a fully booked plane despite having a confirmed ticket. The airline offered rebooking but no compensation. Can the passenger sue? A. Yes. Offloading a confirmed passenger is a breach of contract of carriage. The passenger may claim moral and actual damages. Legal basis. Articles 1170, 2217, Civil Code. PAL v. ICA, GR number 123238. 39. Question A. Truck delivering fragile goods hit a pothole on a public road, causing damage. The trucker claims fortuitous event. Is this a valid defense? A. No. Poor road conditions are foreseeable. The carrier is still liable if the goods were not properly secured or cushioned. Legal basis. Article 1733 to 1735, Civil Code. 40. Question A domestic ship had expired insurance and certificates when it sailed. During voyage, it encountered a typhoon and sank. Is the carrier liable? A. Yes. Sailing without valid documentation is evidence of unseaworthiness. Even if a typhoon occurs, the carrier is still liable due to its negligence in maintaining the vessel. Legal basis. Code of Commerce, Article 587. Loadmasters Customs vs. Glottal Brokerage. Here is Part 6 of the Frequently Asked Questions in Transportation Law, Philippines, continuing with bar-style situational questions for deeper mastery. Frequently Asked Questions, Transportation Law, Part 6, Bar-style situational problems continued. 41. Question A. Warehouse Receipts Company transported goods using its own fleet, then denied being a common carrier. Is this a valid defense? A. No. A business that transports goods as part of its regular operations and offers services to the public, even indirectly, is deemed a common carrier and must observe extraordinary diligence. Legal basis. Article 1732, Civil Code. First Phil. Industrial Corporation v. ICA, GR number 125948. 42. Question A. Bus company posted passengers ride at their own risk inside its vehicle. Can this disclaimer exempt it from liability? A. No. Common carriers cannot unilaterally exempt themselves from liability through signage. Public policy renders such disclaimers void. Legal basis. Articles 1757, 1745, 1, Civil Code. Phil. Rabbit Bus Lines v. ICA, GR number 106322. 43. Question A. Train company refused to carry a passenger with a disability, citing inconvenience and liability risks. Is this valid? A. No. A common carrier has the duty to carry all persons without discrimination, unless refusal is based on legal grounds like safety or capacity. Legal basis. Article 1752, Civil Code. RA 7277, Magna Carta for persons with disability. 44. Question A. Shipper agreed in writing that liability would only be for the declared value of P500. Goods worth P1 million were lost. Can the shipper still recover more? A. Generally, no. A stipulation limiting liability is valid if the shipper freely agreed and declared a lower value. However, if the loss was due to gross negligence, the limitation is void. Legal basis. Articles 1744 to 1745, Civil Code. Yamato v. ICA, GR number 136978. 45. Question A. Passenger died after falling off a jeepney without seatbelts. The driver said the passenger was standing. Is the operator liable? A. Yes. Operators must ensure passenger safety, including providing proper seats or safety mechanisms. Negligence is presumed unless clearly disproven. Legal basis. Articles 1755, 1756, Civil Code. 46. Question: A cargo was shipped under a CNF, cost in freight, term. The buyer claims against the carrier for damage. Can he sue? A. No. Under a CNF contract, the seller contracts the carriage and bears the risk only until shipment. The buyer may have no privity with the carrier unless the bill of lading is endorsed. Legal basis. Code of Commerce Principles. E. Razan Incorporated v. NLRC, GR number 80500. 47. Question: A bus driver ran over a person crossing a pedestrian lane. He said the pedestrian was jaywalking earlier. Is the carrier still liable? A. Yes. The carrier is presumed negligent unless it shows the pedestrian was entirely at fault. The duty to exercise extraordinary care remains. Legal basis. Articles 1755, 1756, Civil Code. Bachelor Express v. ICA, GR number 85691. 48. Question: A carrier claims it cannot be liable for stolen cargo because the theft occurred in a customs-controlled warehouse. Is this a valid defense? A. Not necessarily. If the carrier had custody or control over the cargo when the loss occurred, it remains liable. The burden is on the carrier to prove otherwise. Legal basis. Article 1735, Civil Code. Phil. Rabbit Bus v. ICA, GR number 124985. 49. Question: During an air flight, a passenger developed a medical emergency, and the crew did nothing. The passenger died. Can the airline be held liable? A. Yes. The airline must exercise extraordinary diligence in safeguarding passengers' lives, including responding to emergencies with reasonable care. Legal basis. Article 1755, Civil Code. PAL v. ICA, GR number 123238. 50. Question: A carrier's vehicle was hijacked and cargo stolen. The carrier claims force majeure. Can this excuse liability? A. Only if the hijacking was truly unforeseeable and the carrier proves that it exercised extraordinary diligence in preventing it. Otherwise, the presumption of negligence stands. Legal basis. Articles 1733 to 1735, Civil Code. DHLV Standard Insurance, GR number 156570. Here is Part 7 of the Frequently Asked Questions in Transportation Law, Philippines, continuing with bar exam style problem questions and answers. Frequently Asked Questions, Transportation Law, Part 7, Advanced Situational Problems. 51. Question: A shipping company accepted a shipment of electronics but failed to verify the declared value. Upon loss, the carrier insists on applying the minimal declared value. Is this valid? A. No. If the carrier accepted the shipment without proper verification and failed to object to the declared value, it is bound by it. Furthermore, stipulations limiting liability are strictly construed. Legal basis. Article 1749, 1750, Civil Code. LBC Express v. ICA, GR number 120101. 52. Question: A passenger on a ferry slipped on a wet deck with no warning signs. The ship owner argues the passenger was careless. Is the owner liable? A. Yes. The ship owner failed to maintain passenger safety. The absence of warning signs and a wet deck constitute negligence, triggering the presumption of liability. Legal basis. Articles 1755 to 1756, Civil Code. 53. Question: Goods transported by sea arrived water damaged. The carrier blames a leaking container and denies fault. Is this defense valid? A. No. The burden is on the carrier to prove that the container defect was unknown and not discoverable through ordinary diligence. Otherwise, negligence is presumed. Legal basis. Article 1733 to 1735, Civil Code. Eastern Shipping Lines v. EIAC, GR number 71301. 54. Question A ride-hailing company, e.g. Grab, was sued for injury caused by its partner driver. It claims it's not a common carrier. Is this defense tenable? A. No. Jurisprudence has ruled that ride-hailing companies engaged in the business of transporting passengers for a fee may be considered common carriers, with a duty to exercise extraordinary diligence. Legal basis. Article 1732, Civil Code. Hanseatic v. OI, GR number 194488, analogous, evolving jurisprudence on TNCs. 55. Question An airline issued a non-refundable, non-rebookable ticket. The flight was cancelled due to overbooking. The airline refused to refund. Is this valid? A. No non-refundable applies when the passenger cancels. If the airline cancels, the passenger is entitled to refund or damages. Such clause cannot be used to evade liability for breach. Legal basis. Article 1170, Civil Code. DOTC and CAB rules. PAL v. ICA, GR number 123238. 56. Question A bus line subcontracts one of its trips to another operator without informing passengers. The substitute bus gets into an accident. Is the original carrier liable? A. Yes. The original carrier remains liable for acts of subcontractors under the doctrine of contractual privity and non-delegable duty to ensure passenger safety. Legal basis. Articles 1755, 1759, Civil Code. 57. Question A cargo was seized in transit due to unpaid taxes by the shipper. The consignee sues the carrier. Is the carrier liable? A. No. If seizure was by competent authority and not due to the carrier's fault, it may invoke Article 1734, as a valid defense. Legal basis. Article 1734, Civil Code. 58. Question A foreign carrier limits its liability to $20 per kilo under international conventions. Can a Filipino shipper demand full value? A. No, unless the shipper declared a higher value and paid additional fees. International conventions like the Montreal Convention govern liability on international air carriage. Legal basis. Montreal Convention, 1999. Civil Code only applies subsidiarily. 59. Question A passenger on a jeepney was hit by a low-hanging electric wire. The operator claims it's a public utility's fault. Can it escape liability? A. No. The operator is presumed negligent unless it exercised extraordinary diligence in ensuring road safety and anticipating hazards. Legal basis. Articles 1755 to 1756, Civil Code. 60. Question A warehouse issued a negotiable receipt. A third party acquired it in good faith, but the goods were already delivered to someone else. Is the warehouse liable? A. Yes. A negotiable warehouse receipt must be honored according to its terms. Delivery to a non-holder in good faith does not extinguish the warehouse's liability to the rightful holder. Legal basis. Warehouse Receipts Law, Act No. 2137, Sections 21 to 24. Here is Part 8 of the Frequently Asked Questions in Transportation Law, Philippines, continuing with bar exam-style situational Q&A. Frequently Asked Questions, Transportation Law, Part 8, Advanced Situational Questions. 61. Question A logistics company labels itself as a freight forwarder and not a carrier. It lost goods during transit. Is it liable? A. Yes, if it undertook to transport the goods and exercised control over their movement. A freight forwarder may be deemed a common carrier if it assumes responsibility for delivery. Legal basis. Article 1732, Civil Code. Schmitz Transport vs. Transport Venture, GR number 170052. 62. Question: A ship captain decided to jettison cargo to save the vessel during a storm. The cargo owner sues. Is the carrier liable? A. No, provided that the jettison was justified under the doctrine of general average and proper procedures were followed. Legal basis. Articles 849 to 856, Code of Commerce. Civil Code, Subsidiary. Phil. Home Assurance v. CA, GR number 112973. 63. Question: A passenger injured in a train accident files suit. The train operator claims sabotage caused the derailment. Is this a valid defense? A. Not automatically. The operator must prove sabotage was the proximate cause and that it exercised extraordinary diligence in securing the tracks. Legal basis. Articles 1755 to 1756, 1734, 1, Civil Code. Light Rail Transit v. NAFTA, GR number 161567. 64. Question: A delivery van of a courier company caused a road accident. The company claims the driver was not authorized to drive that day. Is it still liable? A. Yes. Under Article 2180, an employer is liable for acts of its employees acting within the scope of their duties, unless it proves due diligence and supervision. Legal basis. Article 2180, Civil Code. Metro Manila Transit v. CA, GR number 114000. 65. Question: A shipping company inserted a stipulation in the bill of lading that claims must be filed within 24 hours. Is this binding? A. No. Such an unreasonably short prescriptive period is void as against public policy. Legal basis. Article 1744, 2, Civil Code. Phoenix Assurance vs. Macondre, GR No. L24845. 66. Question: A passenger with a confirmed airline ticket was denied boarding due to overbooking. The airline offers rebooking only. Is this sufficient? A. No. The airline is liable for damages and must compensate under the Air Passenger Bill of Rights for unjust denial of boarding. Legal basis. DOTC-DTI Joint Administrative Order Number 01. Article 1170, Civil Code. 67. Question: A shipper sues for damaged goods. The carrier claims improper packaging. Who has the burden of proof? Proof. A. The carrier bears the burden to prove that the damage was solely due to the shipper's inadequate packaging and not due to its negligence. Legal basis. Article 1735, Civil Code. 68. Question: A package shipped through a courier arrived late and was opened. The courier claims it followed all SOPs. Is this a valid defense? A. No. The presumption of negligence arises from delay and breach of confidentiality. The courier must prove extraordinary diligence to avoid liability. Legal basis. Articles 1733 to 1735, Civil Code. 69. Question: A warehouse allowed withdrawal of goods without the surrender of the negotiable warehouse receipt. Is the warehouse liable? A. Yes. Delivery without proper negotiation or surrender of the negotiable receipt makes the warehouse liable to the lawful holder. Legal basis. Sections 11 to 12, Warehouse Receipts Law, Act No. 2137. 70. Question: A shipowner leased the vessel to another party who mishandled the cargo. Can the cargo owner sue the shipowner? A. Only if the lease is a bareboat or demise charter, where possession and control transfer. If it's a time or voyage charter, the shipowner remains liable. Legal basis. Charter party distinctions. Phoenix Assurance v. UCPB, GR number 140866. Here is part 9 of the frequently asked questions in transportation law, Philippines, continuing with more bar exam style situational Q&A. Frequently asked questions, transportation law, part 9, further advanced situational questions. 71. Question: A cargo shipment was delayed due to a port workers' strike. The consignee seeks damages from the carrier. Is the carrier liable? A. No. The carrier is not liable if the delay is due to force majeure, such as an external event like a labor strike that is beyond the carrier's control. Legal basis. Article 1734, Civil Code. Bata v. ICA, GR number 118362. 72. Question: A bus company has a disclaimer stating that it is not responsible for personal items left on the bus. A passenger's bag was stolen. Can the company avoid liability? A. No. The bus company is liable for theft if it fails to exercise extraordinary care, especially if the theft occurred due to its negligence in securing the vehicle. Legal basis. Articles 1755, 1756, Civil Code. Philippine Rabbit v. ICA, GR number 131319. 73. Question: A shipment of perishable goods was delayed because of a mechanical failure on the carrier's vehicle. Can the carrier avoid liability by claiming it acted with due diligence? A. No. The carrier remains liable for damages, even if the failure was accidental, unless it can prove that it exercised the utmost diligence in maintaining the vehicle. Legal basis. Articles 1755, 1756, Civil Code. Transmarine v. ICA, GR number 129450. 74. Question: A common carrier's truck collided with a vehicle driven by an employee on a personal errand. The employee was off duty. Is the company still liable for the accident? A. Yes. The carrier is liable if the employee was acting within the scope of his employment, even if he was off duty at the time, depending on the circumstances. Legal basis. Articles 2180, 1755, Civil Code. Cebu Air v. ICA, GR number 117604. 75. Question: A passenger's luggage was damaged by a port worker during disembarkation. The passenger sues the shipping company. Is the company liable? A. Yes. The shipping company is liable for acts of its employees or agents, including port workers, who cause damage to the passenger's property during the course of transportation. Legal basis. Articles 1755, 1756, Civil Code. Port Authority v. ICA, GR number 163794. 76. Question: A carrier claims the cargo was damaged due to improper packaging by the shipper. The shipper denies fault. Who has the burden of proof? A. The carrier has the burden of proving that the damage resulted from the shipper's improper packaging and not from the carrier's negligence. Legal basis. Article 1735, Civil Code. Solid Cement Corporation v. Court of Appeals, GR number 118055. 77. Question: A carrier accepted goods for shipment but refused to load them on time. The goods were damaged due to the delay. Is the carrier liable? A. Yes. A carrier is liable for damages if it fails to meet its duty of timely and safe delivery, even if the goods were properly packed and labeled. Legal basis. Articles 1755, 1756, Civil Code. Victory Liner v. ICA, GR number 128960. 78. Question: A passenger traveling on a boat died after a fire broke out during the voyage. The owner claims the fire was caused by a passenger's negligence. Is the owner liable? A. Yes, the owner may still be liable unless it can prove that the fire was solely caused by the passenger's negligence. The carrier has the burden of showing it exercised extraordinary care to prevent accidents. Legal basis. Articles 1755 to 1756, Civil Code. Patico via CA, GR number 106532. 79. Question: a car rental company rents out a vehicle to a driver without checking his license. The driver causes an accident. Can the company be held liable? A. Yes. The company is liable for failing to verify the qualifications of its renter, which amounts to negligence in ensuring the driver's competency. Legal basis: Article 1755, Civil Code. Esteban via CA, GR number 100935. 80. Question: a passenger's flight was cancelled due to technical issues. The airline offers only a refund but does not provide accommodation. Is this sufficient? A. No. Under the Air Passenger Bill of Rights, the airline is required to provide appropriate assistance, such as meals, accommodations, and rebooking, in addition to a refund. Legal basis: Air Passenger Bill of Rights, RA 776, Section 13.